What took place on May 31st, 2024 in Georgiawas, a routine shoplifting arrest? What it raises legally is anything but routine. 3 constitutional issues emerge from this footage.
Turn around. Turn around.
By me or by him? Yeah. Why, did you find something? No. So what's going on in the store? You live around here?
Yeah, it's 10-4. The garden center doesn't open until 10, so it's locked. How you doing? Let's do this. Turn around. Turn around. I've got them at the home goods door. It's my off day. I'm just trying to do some traffic enforcement.
Do what?
Traffic enforcement. I guess overtime's overtime, right?
Let me tell you, wait a second.
What's your name? Speak up. Your actual birth given name. Huh? For what? Speak up. I'm old.
What's he got in his pants?
Here's some stuff.
With a tote, Kroger bag, I'm like,
Oh, that's a shoe.
yeah, there's tennis shoes down
In
there.
his pants, nice.
They said they're watching a couple different people.
Oh, okay.
If we can convince people to stop stealing just by being
Dude, you'd think word would get out that everybody gets arrested at Walmart.
yeah.
We've been here.
Videos are on YouTube, Virgo.
We've been here, and 3 of them happen back to back to back while we're sitting in this room. So ridiculous. Those yours? Have a seat. You didn't bring that big enough bag, bro. Had to put a shoe in your underwear. Or, well, technically no underwear. You gotta have that shoe.
No, right.
Which becomes a problem for all of us.
All right, I'll stick around and see if y'all have another one with that. I'm trying to make it my stop sign.
The guy that we were watching, I think he's okay.
Aaron Vaughn took my item from home.
Hey,
Yeah. He just got out of the weight class.
I'll let you borrow mine.
we'll be back.
All right. So what's going on in the store? You live around here? Yeah?
They got all like 20 people to watch.
You want to say anything about what was going on?
It'll make you feel better to unburden yourself. To cleanse your soul.
Y'all want to wait here a second? I'll go grab my ticket book.
21 Central. If you get a return on go ahead and run a criminal history. Mr. It's his name. I just saw.
What's up?
Where's that license there? And we're here. "21 Central." You copied the name of. I would give them the OLM, but I know they didn't hear me.
Yeah. Say whatever you need.
Mr. Have you ever been arrested and convicted or ever been arrested for shoplifting? Now I'm going to run your criminal history, so I'm going to know. You lie to me, I'm going to get very angry, like a father, and I'll scold you with a wagging finger of disappointment. All right? So, again, have you been arrested for shoplifting? How many times? Once? Twice. What's Hogan's number? What's Hogan's number?
Telling them is.
No, what's Hogan's number?
Oh, 70. Where's 70?
21 to 270. He says he's been convicted twice for shoplifting. So ergo, you can't give him a ticket.
No.
Said y'all got 2 more possibles? Or at least 1 more possible? Oh, he's good. Chickened out at the last moment, huh? So Mr. Raymond can switch out my cuffs so I can go dispense happiness to people in the form of traffic tickets. One of those days that a loss prevention officer goes through when they're stealing inside, don't want to take it out on you. What's that?
I said, I hope this one makes it easier with you singing.
All right, gentlemen, I'm walking to my car. Yo. So I don't know your people, so I didn't want to say anything, but he's writing them a citation, which he could be writing them to cover the warrant process, but he does know he can't let them go with 2 convictions, right?
No.
I did think about it. You're not releasing on citation.
I'm about to.
You can't with 2 convictions.
Why?
Policy. If they've been arrested ever before, we can't release them. We have to take them for shoplifting if they want to prosecute.
Y'all want to
Now, you
prosecute?
can issue the citation to cover because what this court started doing is if he's, are you homeless? If he can't make bond in 3 days, you'll have to go back and sign a warrant. That will cover you from having to do that.
Okay.
But we can put on the citation.
Yeah. All right, just let you know.
Fantastic.
First is a Fourth Amendment question. Loss prevention established the initial detention. Officer Raymond's formal arrest followed. Under Chimel versus California, decided by the Supreme Court in 1969, a lawful arrest authorizes a full search of the arrestee's person without a warrant, no exception required. The concealed merchandise recovered from the suspect's clothing was constitutionally obtained. That search is lawfully tethered to the predicate arrest. The second issue carries more legal weight. While the suspect is handcuffed and in custody, the officer asks directly, "Have you ever been arrested or convicted for shoplifting?" That is custodial interrogation. Under Miranda versus Arizona, 1966, the Supreme Court held that any custodial interrogation must be preceded by a full advisement of constitutional rights. The right to remain silent, the right to counsel, the right to appointed counsel if the suspect cannot afford one. No such advisement appears on camera. Practical implement is limited here. The prior record was confirmed independently via radio check, but in a more consequential case, this procedural gap opens the door directly to a suppression motion. Herkimer versus McCarty, 1984, resolved any ambiguity. Custody does not require a police station. Handcuffs at a retail store are sufficient to trigger Miranda. The standard was met. The advisement was not.
Cookie doesn't work around 3 o'clock this afternoon, does it? I wish he wouldn't work any days that we work. I don't understand why he's here.
0071.
Alright, I need to get the court date. I guess that's just the court only date is the same one.
Yeah.
Yeah, I mean, that would be helpful, I guess. I can try to not...
Do you want to take that yellow copy? That's
Oh,
the one
okay.
that needs to be scanned. I'm sorry, the white copy.
Wait.
Yeah. And then... Yep. All right, so
I can do the ABR, but I can't print it out from my computer.
that's fine. I'll grab the ticket before we go, and then they should be able to print it off.
Yeah, they should be able to.
Well, they're gonna book you, and I think you'll have a preset bond, but I'm not entirely sure. People leaving all kinds of.
Can you put that in there?
Put what? Where? What's up?
Can you put this in my bag?
Yeah. I'm gonna put this yellow copy in here too, okay? And then we'll just hold this in the trunk until we get to the jail. That's fine. Yeah.
Welcome to jail. This is Karen. May I help you?
Hey, it's Officer Raymond, ACCPD. I have one mail.
PD 1 mail 10-4. Thank you.
Yes, ma'am.
All right.
Bye.
In. The third issue is the most legally significant and the least visible in the footage. The suspect admitted to 2 prior shoplifting convictions confirmed by criminal history check under Official Code of Georgia Annotated, Section 16-8-14, Subsection B, Paragraph 1, Sub C.A, third or subsequent shoplifting violation is not a misdemeanor under Georgia law. In. It is a felony punishable by 1 to 10 years imprisonment. This case was charged and prosecuted as a misdemeanor. 3 explanations are possible. The prior convictions fell outside a qualifying time window. They were entered in a jurisdiction not cognizable under Georgia's enhancement provision, or prosecutorial discretion was exercised downward. None of those explanations appear in the footage. None are resolved in publicly available court records. What is visible is a charging decision that, on its face, undercharges the offense by at least 1 classification tier. On the citation question, Georgia Code Section 17-6-12 grants officers discretionary citation authority for misdemeanor offenses. It does not mandate release. In. Departmental policy may lawfully restrict that discretion based on an arrestee's prior record. The decision to transport rather than sit was legally and procedurally sound. On use of force, no force beyond handcuffing was applied at any point. Under Graham v. Connor, 1989, the application of handcuffs to a cooperative subject in a non-violent property offense is proportionate and constitutional.
All right, Mr. Ford, we'll be right over here at door 1736, okay? This one over here on the left.
I dropped.
What's that?
I dropped my hat.
You dropped your what?
Okay.
Your hat? Ah, okay. Gonna go around to the other side. Just hang out near that door. I'll grab this for you. There you go, bud. You got any family in the area? Okay. Do you have her number? Is it in your phone? Okay. So they'll let you pull numbers out of your address book, okay? You can't make phone calls or texts, but they'll let you get a number out, okay? I want you to call one of your family members, let them know where you're at, okay? There's a good chance you have a preset bond, and I don't think you need to be staying here.
This was just tickets or ABR?
So the officer who arrested him can't actually print ABRs. He was only able to export it. I was gonna go ask one of the ladies at the front desk if they could print it off.
Okay.
By me or by him? Yeah. Why, did you find something?
No, just asking.
Yeah, it's
I
been
don't want to get
searched.
stuck real quickly. You what? No, you gonna have to speak up. I can hear you. That was at the same volume as what I just heard. You want to try again? Okay.
Your hand to the side, then straight up. It says ready to scan. Straight as that. There you go.
He was asking at some point if he could get his mom's phone number out of his cell phone.
Yeah.
Case outcome, July 7th, 2025, 13 months after the arrest, the defendant entered a guilty plea before a scheduled jury trial commenced. Final sentence, 120 days confinement, 12 months probation, electronic monitoring, consistent with enhanced misdemeanor penalties, but well below the 1 to 10 year Ranjaya third offense felony would have carried. Officer Raymond receives a B+. The arrest was tactically sound and professionally executed. Communication throughout custody and intake was clear, transparent, and appropriate. One documented concern remains: the absence of a Miranda advisement before questioning a handcuffed suspect about prior criminal conduct. Not egregious in this context, but not ignorable either. Mr. Ford receives a C+. He did not resist arrest, cooperated during transport and intake, and accepted responsibility through a guilty plea. That cooperation is noted. However, this was a third shoplifting offense with merchandise deliberately concealed on his person. That reflects premeditation, not a lapse in judgment. ACCPD and the prosecution receive a B-. The sentence achieved accountability, but the decision to charge a third offense shoplifting case as a misdemeanor requires a public explanation that does not exist in the record. 3 key lessons from this encounter. Lesson 1. Miranda is not optional. Custody plus questioning equals Miranda. Full stop. Running a parallel records check does not satisfy that constitutional requirement. Lesson 2. Know your enhancement statutes before you charge. Third offense shoplifting in Georgia is a felony under section 16.814. Officers and prosecutors who miss that threshold undercharge, under-sentence, and undercut the legislature's intent. Lesson 3. How an officer treats a subject in custody is not incidental to the legal analysis. It is part of it. Explaining the booking process and treating a detainee with basic dignity reflects directly on the integrity of the system. Let us know your analysis of this case in the comments below. Subscribe for more legal breakdowns of police interactions. Thank you for watching.
All right, cool.
Don't move.